This courtroom instantly sets a serious tone as the judge acknowledges an existing offer and warns the defendant about a hidden legal risk tied to a separate Wayne County matter. He makes it clear that this overlooked case could drastically impact the outcome, potentially stacking multiple convictions against him. The defendant is urged to slow down and understand the gravity of the situation. What starts as a routine discussion quickly shifts into a high-stakes warning, where one misunderstanding could completely change his legal future.
I realize that there's been an offer extended. I realize what the defendant is saying now, okay? Young man, just listen to me for a second. And why I asked your attorney whether or not he knew about that is because the Wayne County matter can have certain implications for you. Okay. But because your attorney doesn't know about that, he wouldn't have had reason to necessarily investigate what those implications are for you. Okay. And because of the way that the HIDA statute reads, as I see it right now, without going into all of the way things play out, you could end up with a number of convictions and no HIDA. Okay, I don't think that's what you want, right? And that's what I was getting from what you said.
The judge goes deeper into explaining how overlapping cases in different jurisdictions can create serious legal complications. He highlights that even the defense attorney was unaware of the Wayne County issue, which means no proper investigation was done into its consequences. Hypothetical scenarios are laid out, including plea deals and probation risks that could backfire depending on timing. The uncertainty grows as every option carries potential legal danger. It becomes clear that rushing any decision at this stage could lead to irreversible consequences for the defendant.
Before about why you may want to do this. It may be, okay, and your attorney's going to check into this, that, and I'm just going to give you a hypothetical, okay? I'm not saying you're going to do this or anything. That if there's a plea in this case or in these cases, you could maintain a HIDA here, but then lose that one in Detroit. Then the question becomes, what happens to you? What's the probation department going to do? Okay. Otherwise, what you could do, you go through and fight these. If you get convicted, you would get, chances are you may not get HIDA on these, and then you lose that one there, right? Which would not, I know you don't want that, right? So, and I've just given you sort of a thumbnail of it. What I don't want to have happen is for you to be making that decision without a full discussion with your attorney who just found out about this. And he's going to at least have to make a phone call to try to figure out what's going to happen in Wayne. Yeah.
I don't want him to even waste his time.
What?
I don't want him to even waste his time.
It's not a waste of time. He's got to advise you.
I don't want to.
He's got to advise you.
Okay. What the judge is saying, you can fight this case, but if you lose it, you can He's just saying that you made a phone call.
The judge steps in firmly and pauses the proceedings, stressing that it would be unfair to move forward without full clarity. He decides to adjourn the preliminary examination, emphasizing that proper legal understanding must come first. The defendant is told he is not going anywhere due to a no-bond hold, adding immediate pressure to the situation. This moment shifts the courtroom energy from urgency to caution, as the judge prioritizes fairness and due process over speed. Everything is now on hold until proper evaluation is completed.
See what Detroit's going to do. I think it could be a difference. I know you want to fight these cases, but the judge wants to make sure you know the ramifications of Detroit decision in case you lose. So I can have a fair chance.
What?
So I can have a fair chance to know what's going on.
Exactly. I mean, that the problem is this case came back, we set everything real quick, but then there's this other stuff out there. And, part of my job is I got to be fair to the people, I got to be fair to you. And so and if I feel that something's not fair, I'm not going to head down that path. That's my job. Okay. So what I'm going to do, and we can consider it, I'm going to find good cause given all of that. I'm going to adjourn the prelim today. Just listen. And here's the reason why. If I thought that was going to penalize you, I wouldn't do it. Problem is, you're not going to go anywhere anyway, because you're on a no bond hold. They're going to keep you here. So if I thought it was going to keep you in, remember, I'm the one that gave you the bond I gave you, right? So I'm not trying to keep you anywhere. But I got to make sure that you know all of this stuff. Yeah.
Tension rises as the defendant expresses fear about probation violations and possible consequences if the case moves forward. He references conversations with his probation officer and family, trying to understand what might happen next. The judge responds by clarifying that probation officers do not make final legal decisions, correcting misunderstandings. This creates a clash between what the defendant believes and what the law actually dictates. Emotional confusion grows as he struggles to rely on outside advice, while the judge warns him to listen only to proper legal counsel.
If my mom talked to my PO, and if this makes it past prelim, then they're gonna come get me. But my PO is being fair with me.
Well, I don't know that they're going to come get you.
I'm telling you, she said that my PO said that.
POs can say a lot of things about coming to get you. That's not necessarily whose decision it's going to be. All right. I'm just telling you. Young man, here's the thing. You're rushing, trying to make certain decisions. You got a brain, you need to think it through. You need to talk with your attorney to try to figure it out. I understand your mom may have had the conversation. I feel a lot more comfortable if your attorney had the conversation about what they intend to do. Because
Forget about the kids. They never offered you. You get convicted, he's worried about what the county says. You're not going anywhere because when county says. That's how the mom's home. And I was trying to do it.
And that's why, can I just say this? One of the reasons you're still here, because remember, the bonds I gave you, you could post and get out, right? And you have to ask yourself, why are you still here? You're still here because of that Wayne County hold.
Right.
You're not going anywhere.
Right. They said, sorry.
Go ahead.
They said, if my PO said this directly, if this is like made over to circuit court, then she's going to come get me. I'm gonna be violated for probation. And that's, of course, not making a deal as well.
In the final stretch, the courtroom moves into bond corrections and procedural adjustments that resolve earlier confusion. The judge revisits bond amounts, clarifies prior rulings, and ensures proper credit for time served is accounted for. Attorneys and the court work through conflicting details before finalizing updated conditions. The defendant is repeatedly advised to follow his attorney's guidance instead of rushed decisions or external opinions. Eventually, the case is adjourned, with a clear warning that careful legal understanding is essential before the next hearing.
But I said, can she be fair? Can she please let me make it past preliminary exam? And if the charges are dropped, and she's not violent, she said that she would.
But she didn't tell you that.
She told my mom that. My mom told me.
See, is your mama?
Your mom wants to know. Phone number. Judge, while we're waiting for this, there's one other matter. You were gracious enough to give this young man a PR bond. We all expected him to get out
Released, I'll set it, I'll just,
$100 bond.
yeah, I'll just make it $100 bond, so he's getting credit.
That's
You
on,
understand that, young man?
that's on case 25.
This is why you need to, you've got a very good, very experienced attorney. You need to listen to him. Okay? Because I think you're making decisions based upon what you see and not understanding everything. All right, that's what I'm seeing. So the reason that he's asking for the bond, I gave you a PR on the one case. Since you could be released on that case without posting it all, right? You're not getting credit on that case for the time that you're in. So what he's asking me to do is to give you a nominal bond of $100 so that you at least are getting credit while you're sitting there. Follow that? Okay. My next day that I have, and I can, which is when it would have been set, other than trying to get everything set, is February 3rd. Will that work for Mr. Tribolowski? Will that work for your witnesses? All right.
Joe, that he not be released to Wayne County? Is that possible?
I typically don't get involved in that. So it's usually that they won't release him. What Wayne County's not going to come and get him because they know where he is. They put their hold in. Once we're done, then they're going to come get him. I don't know where in the process they're looking at trying to do that.
One last question. I guess what to say. Tell me. I think the judge is saying that because you haven't been adjudicated, if there's any movement on this case, when you come and sit, let you sit here.
They're not, because they can't. That's what I'm doing. And I'm just doing, quite frankly, you need to start listening to folks. And when I'm saying that, young man, you need to start listening to folks that have law degrees. You're listening to somebody else, right? And you need to start listening to that man sitting next to you about what you should do next. Because right now, as I see it, and what you're telling, you're making all the wrong calls. I gave him the 25 personal on the W.
25.
I'm gonna change that bond to $100 cash or surety. I'm going to adjourn the preliminary examination to February 3rd, 2026 at 9 a.m. Let you check all of that information out. And I don't have a problem going forth, but let him do it with everything in front of him as to what was going to happen. Right?
Adjourned to February 3rd, Judge, 9 a.m.
9 a.m. before me on both cases. Yes, sir.
Are you able to make the $100, the change to the $100 effective last week, Thursday, so he gets all his credit? It's like 4 days, but it's 4 days. I don't know if it is, or we just have to fix it later.
Judge, this young man is saying he gave you PR bonds on both cases. I don't recall that.
No, I didn't give him a PR on the,
50,000, 10%.
right, I gave him, well, no, I see it. I did. I gave him a PR on both cases. That's, so he shouldn't even be here right now.
I thought you had left the 50-10%.
No, I'm looking at the Caro and it was $25,000 personal recognizance on that one and on the other one. Well, no, something's wrong here. That's not right. I think they got the wrong,
I thought you
they
said,
got the wrong amount. What do you have on that bond? The 1637 should have been left the same because you said that you could post that one. That was the one I had already used. The new charge that came up was, it was the court's intent to do the PR.
Last week I showed you 50,000%.
Correct. And so on 1637, that bond should have been the 50,000 cash surety because he was going to be able to post that. So bond will be continued on that case, that being 1637 at 50,000 cash surety. That case, because that's the one that he could post, right? In the other case, what I'll do is I'll increase his bond to $100 cash surety, and I'll do the bond. We were here on Thursday. What day was that? 8th. Non-pro-tunc to January 8th. So he'll get the 4 days credit on that since he hasn't been released.
Judge, on the first case, is it 50,000 or is it?
It's 50,000 cash surety.
No, you took away the 10%?
It was, I don't think it was 10% before.
Yeah. Well, that's what we read it. Or
I just want to make sure I heard you. Joe.
Hang on a second. Let me just,
From Christmas, the 23rd.
let me make sure, because it should have been a bond form in here.
On the 23rd, I had.
What do you have on the 23rd?
Yeah.
That's where I'm gonna put it.
Yeah.
Those bonds should have been $50,000, 10%. And then his bond will continue at the $50,000, 10%. I knew he had to post. I knew to post it was gonna be 5,000. That's what I knew. So that will be the 10% bond on that one. The other one raising to $100 so they can be credit retroactive to the 8th. Yeah,
I can't post that, the first bond anymore. Sorry.
no, don't be sorry. You can't post it. Give him credit because you're not posting. You know what I'm saying? That's how bond works. If he said the bond. So you're giving credit now every day on both cases. Do you understand what posting bond means?
That 50,000, 10%.
Right, you can't do that. So in return, you get all, while you're sitting in jail, you get credit, but you can't post it.
all right. Thank you. We'll see you in a couple of weeks after they check on everything, young man. Thank you.
Thank you, Judge, for your consideration.